Dar es Salaam, the financial capital of the United Republic of Tanzania and the largest city in East Africa, was the host city of the 5th African Union Judicial Dialogue and the Conference on the Implementation and Impact of Decisions of the African Court on Human and People's Rights. This city, considered as the New York of Africa because of its tall buildings, is also the main port city in the United Republic of Tanzania. In the heart of Dar es Salaam is found the Julius Nyerere International Convention Center, which was the venue for the 5th Judicial Dialogue and the Implementation Conference of the decisions of the African Court.
I invite you to stand as we receive His Excellency the Vice President of the Republic.
The 2021 Judicial Dialogue began with the arrival of the Vice President of the United Republic of Tanzania, Dr. Philip Mpango, followed by the anthems of Tanzania and the African Union. This 5th Judicial Dialogue centered around the credibility of the judiciaries in Africa under the theme, Building Trust in African Judiciaries. Speaking on behalf of the African Union, the President of the African Court on Human and People's Rights, Honorable Justice Imani Aboud, welcomed all participants.
Allow me to first extend to you a warm welcome to Dar es Salaam, otherwise known as the Heaven of Peace. I would like in particular to express my gratitude and that of the Court to Her Excellency, the President of the United Republic of Tanzania, for designating His Excellency Dr. Philip Mpango, Vice President of the United Republic, to launch this important event. On behalf of the African Court and my own behalf, I extend appreciations to the government of the United Republic of Tanzania for the continued support afforded to the African Court as our host country.
Participants at the dialogue listened keenly to the opening statement by the Vice President of the United Republic of Tanzania, who stressed on the importance of the theme of the dialogue, which is building trust in African judiciaries.
To my mind, the choice of the theme of this dialogue is in itself an honest admission of the limited trust or confidence that our people have in African judiciaries. And therefore, in order to earn their trust, we have to know and work hard to find a cure to what are the strongest factors and concerns that diminish trust in African judiciaries. Allow me to emphasize 3 key areas of focus in building trust in our judiciaries. One relates to ensuring independence and impartiality of the judiciary. The second priority area of building trust is tackling corruption head-on. The third priority area is harnessing the use of ICT in court proceedings and other functions. I believe the judiciary may win the confidence of the people by increasing its transparency and accessibility.
Authorities of the African Court handed over a symbolic gift to the Vice President Dr. Philip Mpango and later on took photographs to immortalize the event. After a short break, during which participants exchanged civilities, the different delegations went back into the conference hall for the dialogue proper. The 2021 Judicial Dialogue was organized in 4 sessions. The first on the consideration of the report on the implementation of the decisions of the previous judicial dialogues, the second on the independence and impartiality of the judiciary, the third on the efficiency and effectiveness of the judiciary, and the fourth on the conclusion and recommendations of the 5th Judicial Dialogue. As concerns the independence and impartiality of the judiciary, participants were enlightened on the methods of appointing judges, the duration of judges in office, the remuneration of judges, and the ethics of judges. Honorable Justice Fatuma Sikale, the representative of the Chief Justice of Kenya, gave her experience on how a judge should be impartial and independent.
The beginning point is the judges who are recruited, they must pass a threshold that they are people who can be relied on to make sound judgments, irrespective of who the parties are. So that really is a beginning point that for you to be able to get a judiciary that is credible, that judiciary will have to be manned by men and women of integrity. And for Kenya, after the passing of the 2010 Constitution, we endeavored under the Constitution that we will have a clean break from the past, and we will not have judges appointed at night, but the whole process must be transparent.
Obstacles to trust in judicial systems in Africa were tackled during the dialogue.
There might be some interferences in the independence of the judiciary, either from the 2 other branches of government or even from individuals in terms of influencing the decision. Of course, the other thing we are talking about is the effect and the impact of corruption and bribery in terms of dealing on the judiciary, and that touches directly on the ethics. And that's why in our presentation we also covered about ethics and conduct of judges, and we say the judges themselves have to be self-restrained, and that is they have to perform their jobs without giving heed to any influence from outside.
In the different panels, participants reflected on ways and means of fostering sustainable trust in the justice system.
We are advocating for some kind of autonomy when it comes to the funding of the judiciary. That is very important, because once there's appropriate funding, they can be able to embark on capacity building for all judicial officers. They can be able to, for example, have e-justice, whereby they would not have to be recording proceedings by hand. They will be able to make good use of IT, have the courts properly equipped in terms of IT. That will facilitate and make the job easy for the judge and dispensation of justice in the long run, because justice delayed is justice denied.
So they should guard against corruption and bribery. And in this regard, we looked at the general principles and the international law which regulate ethics, and actually they are part of many of our laws in Africa, and the judiciaries are regulated by those ethical committees, which actually have a composition from the judiciary and members from outside. Of course, we drew the example of Kenya, which is a peculiar one in terms of appointment of judges, which is a new approach. That is, judges have to apply for the job, get interviewed in public to increase transparency.
Participants at the dialogue were of the opinion that whether in domestic or international justice, the question of trust is paramount, as it is a guarantee for stability and security for any society. According to the participants, without trust no judicial institution can adequately accomplish its task and is therefore bound to be criticized by all sides. They advocated for e-justice, amicable settlement and cooperation between domestic and international courts as some of the ways of ensuring efficiency and effectiveness of the judiciary in Africa. Preceding the judicial dialogue was the conference on the implementation and impact of the decisions of the African Court on Human and People's Rights. The conference was opened by a representative of the President of Zanzibar.
It gives me great pleasure and honor to officiate at this important conference on the implementation and impact of decision of African Court on Human and People's Rights. Allow me to begin my address by expressing my personal gratitude to the African Court on Human and People's Rights, and in particular to the President of the Court, Honorable Justice Imani Aboud, not only for inviting me to be part of this important conference, but also for the effort taken to convene this continental gathering of eminent personalities to reflect on the implementation or impact of decision of the court.
This three-day conference was organized in 9 sessions, beginning with the general overview of the problem of the implementation of the decisions of the African Court.
There's a problem, but we are not really able to really pinpoint and say this country is because of this country is because of this. You can imagine 11 judges from different judicial traditions, legal traditions, sitting around a table. I think it's part of the general democratic retrogression that has been observed on the continent in the last few years. As a judge of the court, it's not very easy for me as to why states do not implement our decisions. I think it may be a good idea to also speak to some of the representatives of states who are here. But from where I sit, I think that part of the problem is a misunderstanding of the framework that states put in place, which is the African Court. Because the court was set up by a treaty. And the moment you enter into a treaty, you are obligated to implement all the decisions adopted by that treaty body. And that is very clear from Article 30 of the protocol, where states have undertaken to implement.
The issue at stake during this conference were the reasons for the non-implementation of the judgment of the African Court by some African states. In fact, only 7% of the decisions delivered by the court have been enforced.
Each country has the reason, different reasons. Some just because they have been losing cases. Some, they complain that, okay, we are interfering the sovereignty of those states. And some, according to my observation and many others' observations, just because they don't know the procedures and the law governing the court.
According to some participants, the non-compliance with the decisions of the African Court may be as a result of the fact that the protocol creating the court does not provide any sanction for non-compliance. The registrar of the African Court had a contrary view.
At the international level, it's difficult to charge a state for contempt because how do you enforce that? But in my view, the non-implementation is not as a result of the fact that there's no sanction in the protocol. I think in my view it's just a lack of political will. Because if a state has a will, the political will to implement a judgment, it will not do so because there is sanction. It will do so simply because it is its obligation to do so. The state has taken the international obligation to implement judgments of the court to respect human rights. So you don't need any sanction for you to be able to comply with undertakings that you have made at the international level.
Participants at this conference shared experiences on the implementation of international courts and tribunals' decisions, as well as best practices, lessons learned, and challenges in the implementation of the decisions of the African Court in domestic systems of respondent states. A senior state counsel from Kenya gave her experience on the challenges of the court's decision in Kenya.
Kenya has had one case before the African Court on Human and People's Rights, and this is the case known as the Ogiek case. But, you know, the title of the case was the African Commission on Human and People's Rights versus the Republic of Kenya. This case was touching on various violations that the Ogiek community brought, that alleging that the Kenyan government had, violated its land rights and its property rights and its right to religion, right to enjoy culture. So as a country, one of the challenges that we have faced in implementing this decision, because the court did rule in favor of the applicants, is that it is a historical problem. It was not the first time that the Ogiek have laid claim to the Mau forest, which was the subject property that was in dispute, as their ancestral land.
The institution of the judiciary in Rwanda was also presented during the conference.
There are many cases in which the African Court for Human and People's Rights has tried, and where Rwanda was a party. Some of the cases have already been completed, and as you heard, some of them are not executed. Why they are not executed, I think I'm not in a good position to tell that, because as I said, I'm coming from the judiciary, not from the government.
The situation of Cameroon vis-à-vis the court was equally presented by a member of parliament of the National Assembly of Cameroon.
We are doing advocacy and sensitization in National Assembly so that Cameroon gives this declaration, because in matter of human rights, it is very important. If we want to avoid war, if we want to avoid social crisis, we should promote and defend human rights. It is not a matter of political parties.
After the different experiences, participants exchanged views as to what can be done to facilitate implementation.
The strategy that we have adopted now is to engage with state parties, to have some open and sincere discussion about how to solve this challenge, because this is the African Court and it belongs to Africans and it is owned by the African Union. So if the court cannot do its work effectively as it is expected to, I think we will lose the confidence of the Africans, and also we want to exercise our mandate as it is in the law. So such kind of engagement, we think that will be the only solution to discuss and find the way.
As concerns the implementation of the decisions of the African Court, experiences were shared by participants from different countries. The representative of Tanzania was one of them.
I would say one doesn't see much of an impact, especially because rarely do lawyers appearing in courts refer to the decisions of the African Court while arguing cases before the courts. That is one. Secondly, the courts themselves, the judges sitting in those courts, even though it is open for them to refer to such decisions, they rarely do so.
The experience of the civil society, particularly on advocacy, was not left out.
On the question of the impact of the African Court decisions on advocacy, I think what I would say is, I think the advocacy by civil society should first and foremost focus or try to see what are the issues behind non-implementation, and then this can inform the advocacy that they are going to take. many challenges, many loopholes have been identified by member states as challenges for implementation. And I think the starting point for the CSOs will basically be to look at those challenges and then try to find solutions.
One of the sessions dwelled on the role of the African Union in ensuring the implementation of the court's decision. Some participants think the African Union is doing very little.
Actually, it's not doing much. There are institutions which are supposed to handle the whole question of implementation of the decisions of the African Court on Human and People's Rights under Article 30. But very little is being done by the various authorities within the African Union to make sure that these decisions are implemented to the letter. I think there is a problem when it comes to enforcement of the implementation process.
The role of the African Court in promoting the implementation of its decisions was lauded by some participants.
I think the court is doing its role. One, under the rules of procedure, the court has been making sure that not only the parties to the cases know of the decisions, but also the various authorities within the African Union are informed for purposes of implementation. And then when the judgment comes out, it is disseminated. So the court is doing its role. It is hearing the cases, making decisions, and making decision known. So it is up to the African states, particularly the parties, to ensure that the decisions are implemented.
A special advice was given to countries that have ratified the protocol creating the court, but which are still reluctant to send in their declaration permitting NGOs and individuals to seize the court.
My main advice and call to especially our political leaders and then our senior bureaucratic leaders who serve the politicians is please strengthen these judicial institutions at the national level, at the regional level, at the continental level. We've seen a recent trend where several heads of state, after leaving office or after being removed from office, end up in either criminal trials, transitional justice trials, or sometimes even civil cases brought by the citizens. This is happening now to Blaise Compaoré, former president of Burkina Faso, also to his brother Francois Compaoré, arising out of the killing of some investigative journalists. This happened to Hosni Mubarak of Egypt. This is happening to President Omar al-Bashir of Sudan. This has also happened in the context of the ICC to former President Laurent Gbagbo of Cote d'Ivoire. It has happened to President Uhuru Kenyatta and Deputy President William Ruto, and so on. So if you have strong institutions, and as you may know, recently President Jacob Zuma, when he was displeased with the decision of the courts of South Africa, wanted to bring his case to the African Court on Human and People's Rights. But unfortunately for him, while he was in power, he had not made the declaration that would allow his country to receive cases here. So we just urge them, while you're in power, strengthen these institutions. Make sure they're independent. Make sure they're competent. Make sure they have facilities to do free and fair trials, because you may need them when you leave power.
After the conclusion and recommendations highlighting the possible solutions and ways of improving the implementation and enhancing the impact of the African Court's decision, the conference was closed by Ambassador Fatuma, representing the Minister of Foreign Affairs of Tanzania.
On behalf of the Minister for Foreign Affairs and East African Cooperation, Her Excellency Madam Liberata Mulamula, and through her, on behalf of the government of the United Republic of Tanzania, I would like to commend the African Court on Human and People's Rights for organizing this important conference on the implementation of the decisions of the court. Due to the success of this conference, the government called upon the court to continue in the same spirit of organizing different platforms which create awareness and capacity building to member states on matters of justice and human rights. I urge all the participants of this conference to apply the knowledge acquired during these 3 days to to improve implementation of the court's decision in your respective countries and hence improve the human rights situation in our continent.
Participants left the Julius Nyerere International Convention Center in Dar es Salaam convinced that the implementation conference will enable many more African states to enforce the court's decision by recognizing its binding character and enforceable nature as stipulated in Article 30 of the protocol establishing the Court on Human and People's Rights.